government kick people out of the country without having to make a case in a court of law. That's the central issue being argued right now between the White House and many aspects of the judiciary. And these 7 pages in my hand are the most recent ruling from Thursday. A Republican appointed judge, you could say in essence, ruled against the Trump administration. But the reason I'm about to read you these 7 pages and move through as quickly as I can is because I think it perfectly encapsulates one of the biggest issues being debated in America right now, effectively, is due process at stake. Could you, myself, could American citizens, people, immigrants who are here, could they be kicked out of the country without the government having to make a case in a courtroom, which in this case they say Mr. Kilmar Abrego Garcia is dangerous. He's a gang member, he's a threat to the American public, and so as such, not only should he not have been in the United States, where he's not from originally, there's no way he's coming back. I'm going to read these 7 pages to you. I'll give you some context on who is saying what and why throughout, but I think it's just pretty remarkable, and this is a big story we've been covering on CBS News. I'm Errol Barnett, a CBS anchor. Hopefully you join me each weekday at 7 a.m. for the CBS Morning News. If not, I still think you're going to get value out of this, and at the end of the video I'll speak about some other things to keep an eye on. Okay, so in my hands right now is the motion to catch you up on the story. Kilmar Abrego Garcia is originally from El Salvador. He was in the United States, was living in Maryland with his wife, and he was deported by the Trump administration to El Salvador with many others, as the Secretary of State was using the Alien Enemies Act, which effectively provides other powers so long as they believe the people they're deporting are a threat to national security. Mr. Abrego Garcia had a TPO, a protective order, which means that the government had already, through other legal cases, ruled that he should not be deported. He had a protection from deportation because of his allegations that he might be retaliated against by a major and powerful gang in El Salvador, that there were allegations that he had links to. The government has continually pointed to these allegations from an informant that Kilmar Abrego Garcia is a gang member and a part of MS-13. He, though, and his family, through his lawyers, deny that completely, and the government has not yet shown specific evidence proving as much. So the administration is fighting this effort to have Mr. Abrego Garcia brought back. Previous judges have already ruled that the government needs to facilitate his return. The Supreme Court has ruled, the Trump administration appealed. The Supreme Court ruled that, yes, indeed, the Trump administration has to facilitate the man's return. And this was the Trump administration's effort to have a stay on that decision and say, no, delay that, pause that while we fight out the issue. This judge says no. And he was appointed by Ronald Reagan back in the day. He, along with 2 other democratically appointed judges, King and Thatcher, all are in agreement that the executive branch, i.e. the Trump administration, does have to bring this man back. So let's quickly walk through these 7 pages. Wilkinson, the judge, his name is Judge J. Harvie Wilkinson III, circuit judge, with whom King and Thatcher, circuit judges, joined. That's Robert King, that's Stephanie Thatcher. These are the other judges appointed by previous presidents, Clinton and Obama, respectively. Upon review of the government's motion, the court denies the motion for an emergency stay pending appeal and for a writ of mandamus. The relief the government is requesting is both extraordinary and premature. While we fully expect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. And that kind of points to the backstory. What they're saying is, yes, the executive branch has to carry out foreign policy. That has been the Trump administration's defense. And they assert its Article 2 powers. That's the part of the Constitution that says the executive branch can do so. They won't micromanage the efforts of a fine district judge, that was Judge Zenas, who originally ruled that the Trump administration had to bring this man back, and attempting to implement what effectively is now the Supreme Court's recent decision, which upheld that they got to bring him back. Now, let's get to page 2. It's only 7 pages. Stay with me. It is difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. President Trump and even the president of El Salvador in the Oval Office earlier this week both said he's already there, he's dangerous in America, so we can't force them to bring him back to us, and he can't come back here because he's dangerous. Judge Wilkinson III states clearly, this should be shocking not only to judges but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. The judge is saying even if what you're saying is true, you have to prove that in a court of law here in the United States first before you can act on it. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. That's correct. Moreover, the government has conceded that Abrego Garcia was wrongly or mistakenly deported. That's a position the Trump administration previously admitted. Why then, this judge asks in the ruling, should it not make what was wrong right? The Supreme Court's decision remains, as always, our guidepost, and that decision rightly requires the lower federal courts to give due regard for the deference owed to the executive branch in the conduct of foreign affairs. And then he cites previous rulings that support that position. That would allow sensitive diplomatic negotiations to be removed from public view. It would recognize as well that the facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. So the judge is saying, yes, the Trump administration said it needs to elicit the Alien Enemies Act, which allows them to deport people without due process because of national security concerns, and they just don't need to explain details publicly. The judge is saying bringing him back still allows privacy for the executive branch to continue doing what it's doing. And he's citing this previous Supreme Court decision, which upheld the lower court's decision to bring the man back. The Supreme Court's decision does not, however, allow the government to essentially do nothing. It requires the government to facilitate, and he's quoting this phrase, Abrego Garcia's release from custody in El Salvador, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. So the judge is echoing the Supreme Court's ruling and saying, not only do you have to bring him back, you have to get him back, you then have to let his case move through the courts and prove that he's a criminal as part of MS-13 and needs to be kicked out. You still have to do that as well. It requires that steps be taken. The Supreme Court has made perfectly clear. I think I just said that. Thus, the government's argument that all it must do is remove any domestic barriers to Garcia's return is not well taken, and in light of the Supreme Court's command that the government facilitate Abrego Garcia's release from custody in El Salvador, the government, the executive branch, the Trump administration had previously said, well, look, even if we had a plane at the airport in El Salvador, we can't force the country to release him. They're making the position clear. You've got to get him out, you've got to get him back to the US, and you've got to prosecute him through this regular court of law. There was an argument previously about wording. The lower court judge who initially compelled the administration to bring him back said to facilitate and effectuate. When it hit the Supreme Court said, yes, the Trump administration should facilitate, but the lower court went too far in saying it needed to effectuate. I'm summarizing, I'm paraphrasing. The Trump administration has pointed that as a win. We don't have to effectuate his return. This lower court judge, in ruling against the appeal, is now defining the word. Facilitation does not permit the admittedly erroneous deportation of an individual to the one country's prisons that the withholding order forbids, and further to do so in disregard of a court order that the government not so subtly spurns. Also citing that the TPO specifically said the man should not go back to this specific country because of retaliation. The judge goes on in quoting, "Facilitation does not sanction the abrogation of habeas corpus through the transfer of custody to foreign detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would also reduce the rule of law to lawlessness and tarnish the very values for which Americans of diverse views and persuasions have always stood." The judge is being 100% clear on what he means, what the Supreme Court means, and what the original order meant when it said the Trump administration had to facilitate Abrego Garcia getting back. And you really don't hear anything more clear, more stark, more striking from a judge on any topic than saying it would reduce the rule of law to lawlessness by interpreting the law in the way the Trump administration is. Now he tips his hat somewhat to the government's position. The government is obviously frustrated and displeased with the rulings of the court. Let one thing be clear: court rulings are not above criticism. Criticism keeps us on our toes and helps us do a better job. He cites for that. Court rulings can overstep, and they can further intrude upon the prerogatives of other branches. Courts thus speak with the knowledge of their imperfections, but also with the sense that they instill a fidelity to law that would sorely be missed in their absence. So he's saying, yeah, courts can get things wrong and go too far, but we acknowledge that. Energy in the executive is much to be respected. He cites the Federalist paper here. It can rescue government from its lassitude and recalibrate imbalances too long left unexamined. The knowledge that executive energy is a perishable quality understandably breeds impatience with the courts. Courts in turn are frequently attuned to caution and are often uneasy with the executive branch's breakneck pace. And he's nodding that he understands that any presidency has 4 years and needs to do things quickly to achieve what a president has been elected to do. Meanwhile, courts have to make sure that the way they do it is legal. And the differences don't end there. The executive is inherently focused upon ends. The judiciary much more so upon means. Ends are bestowed by the executive on electoral outcomes. Means are entrusted to all of government, but most especially to the judiciary by the Constitution itself. That's what I just explained. The executive possesses enormous powers to prosecute and deport, but with powers come restraints. If today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? The threat, even if not the actuality, would always be present, and the executive's obligation to, quoting the Constitution here, take care that the laws be faithfully executed would lose its meaning. Once again, a very clear and stark factual statement from a federal judge appointed by Ronald Reagan way back in the day on the issue of due process when it comes to the Trump administration and Kilmar Abrego Garcia. I mean, that is unambiguous. Today, both the United States and the El Salvadoran governments disclaim any authority and or responsibility to return Abrego Garcia. And here he cites that Oval Office meeting on Monday between the two leaders when the president said, we can't bring back a terrorist, in his words, someone who's dangerous. And the El Salvadoran president said, he's not from the U.S. The U.S. isn't telling us to send him back. Why? We can't force someone to come to the U.S. that isn't even allowed to be in the country. So this judge cites that. We are told that neither government has the power to act. The result will be to leave matters generally, and Abrego Garcia specifically, in an interminable limbo, without recourse to law of any sort. The basic differences between the branches mandates a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. He's not acknowledging the friction points, but saying that the two need to work together in this country. Too often today, this has not been the case, as calls for impeachment of judges for decisions the executives the executive disfavors and exhortations to disregard court orders sadly illustrate. And there is a citation there of the president's many comments saying that federal judges that have ruled against him need to be impeached. This judge is saying that's not a good thing. Here we're at the final page. It is in this atmosphere that we are reminded of President Eisenhower's sage example. He's going way back for this one. Putting his personal opinions aside, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision in Brown v. Board of Education II, to desegregate schools with all deliberate speed. That's in quotes. And then he cites an address by Eisenhower at the Oval Office. This great man expressed his unflagging belief that the very basis of our individual rights and freedoms is the certainty that the president and the executive branch of government will support and ensure the carrying out of the decisions of the federal courts. Indeed, in our late executive's own words, unless the president did so, anarchy would result. So in making an historical example and comparison, this judge is saying that if the two branches did not work together in the executive carrying out the court's rulings and the courts carrying out the executive's position and orders, anarchy would reign in America. And we're at the final few graphs here from Judge Wilkinson and the other two circuit judges. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment we can only sparingly reply. So he's saying judges will keep taking hits and they can't respond publicly point by point. So courts will be damaged and the respective courts will be damaged. He goes on to say, the executive will lose much from a public perception of its lawlessness and of its attendant contagions, all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been. And law in time will sign its epitaph. Almost getting poetic here, which you don't always hear in federal rulings, but the judge is acknowledging that the Trump administration risks legitimacy in the eyes of the people. There was a recent rally for Senator Chuck Grassley of Iowa, a Republican, in which someone at one of his town halls said, so if I have a fee for a speeding ticket, can I just not pay it? I'm angry. Is Trump going to bring that man back? Another man said. So people may interpret the Trump administration flouting judicial orders as their green light to avoid the laws and other orders against them. Wow, okay. It is, as we have noted, all too possible to see in this case an incipient crisis, but it may present an opportunity as well. He's opening a window and a glimmer of hope in these closing lines. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. Closing line from Judge Wilkinson III. In sum, and for the reasons foregoing, we deny the motion for the stay pending appeal and the writ of mandamus in this case. It is so ordered. This, I believe, now gives you an example of why this decision from Thursday, is described as blistering, as striking. I say it's powerful, and those words are not from a democratically appointed federal judge. For those of you who might think that is someone who is more liberal, this judge was appointed by Ronald Reagan. He was actually pretty well liked by George W. Bush, I believe, and was on the shortlist for the Supreme Court at one point. You've got two judges appointed by Democratic presidents joining him in this decision, Judge Robert King and Stephanie Thacker. And this case isn't over. President Trump in the Oval Office just a few moments ago, I watched it here from my office, went on to speak about the crimes that Mr. Abrego Garcia is accused of. They've shown evidence from his 2019 deportation order. But in all of the documents that have been released, no evidence of any terrorist activity or linkage has been made public. And the temporary protective order noted that there was really only one informant that suggested this man was a member of the dangerous gang from El Salvador. In the comments, post what you think the Trump administration should do if you really believe that due process is at stake. And are you like some of these folks in town hall saying, if the Trump administration doesn't have to follow judges' rulings, neither do I? Is that really something, or is that overblown? Let me know what you think in the comments. I certainly want to hear what you all make of this, because it's a big issue that we're tracking, and some days there aren't enough minutes to explain it and break it down the way that I've been able to do. Also, I encourage you to get out there and read this yourself. It's on cbsnews.com, and the article about this, and go through the words and see what you make of this judge's position. Thanks for joining one of my first lives. I'll try and do this semi-regularly. It's a little something different. I'm in my office here on a Friday and wanted to see if this resonated with you as much as it resonated with me. But do enjoy your weekend. Post what you think down below. There's also a link to some of our most recent reporting on the CBS Morning News on this topic and other big stories. And also I've shared a link to a playlist of some of my coverage of the Trump administration from the first time he was in the Oval Office. It's also an example of some of the big legal issues that he found himself tangled in. All right, thanks for tuning in, everyone. And if you like this, I'm sure you'll like what's coming up next.